Hello, everyone, and welcome to the webinar channel of the Association of Certified eDiscovery Specialists. My name is Mike Quadraro, and I am the president of ACEDS. Today, we are joined by BIA, our partner for our webinar, entitled Ethics in eDiscovery. BIA is an industry pioneer in forensics in eDiscovery. It provides solutions across the eDiscovery spectrum, and one of the really noteworthy things about BIA is their entire project management team is CEDS certified, and so we're proud of that, and I know they are too. So kudos to them for that. So let's get into it. Before we get started, however, let me just say that we love questions. We're always happy to take your questions, and you could submit your questions at the bottom of the screen in the widget. Also, if you'd like a copy of the slide deck from today, you could download that from the resource widget also at the bottom of your screen. Without further delay, let me introduce our presenters today. Brian Schrader is the co-founder of BIA. He's got 25 years plus experience in technology and law, and he is a pioneer of computer forensics. I've known Brian for many, many years. And we are also joined today by Barry Schwartz. Barry oversees BIA's advisory division. He's got 35 plus years of legal technology consulting, and he specializes in electronic discovery. All right, without further delay, let me hand off to Brian. Take it away, Brian.
Thank you very much, Mike, and thank you everybody for joining us today. We've got quite a large group attending, so hopefully we'll get some interesting questions. You can submit them online. We'll be answering them towards the end. We'll also, I think, be putting up a blog post about it as well, to the extent we get some questions at the end. So today's presentation is kind of very at a high level across the entire EDRM spectrum. So from the very first kind of triggering event through legal holds and collecting data, identifying, and even how you review that information and produce it, kind of going to touch on each one of those things as we go through and show how how ethics plays into each one of those steps across the board. But what it all comes down to really is this model rule that has been adopted by a number of states, and really this is probably the most cited rule when you see courts talk about ethics in the contents of eDiscovery. And it's this idea that lawyers need to be competent or need to competently represent their clients, and it requires the right not only legal knowledge and skill, but making sure that you understand all of the issues, and when it comes to eDiscovery, that includes the technology. And as you can see here in the state of California, there's a specific rule that's been cited an awful lot, but that the California Bar came out with. Depending on factual circumstances, a lack of technological knowledge in handling eDiscovery may render an attorney ethically incompetent to handle certain litigation matters involving eDiscovery absent curative assistance. And there have been quite a number of individual states that have come out with similar rules and requirements saying that to the extent you practice in an area that involves eDiscovery, you have to be competent in representing your clients. You have to be competent in that technology, or at least understand it. And there's kind of three ways that the authorities have put out to meet this. And of course, the first of that is having the sufficient skill and knowledge and obtaining the right learning to fully understand what the technology implications are to the particular case you're working with. Again, whether that involves identifying data or how you handle that data, or even how you issue legal holds. So the first thing, of course, is just being able to know it yourself and handle that. The second is to associate with, just like, if you go into a case, you're going to hire an expert to testify on damages, or you may hire an expert to testify on any kind of technical aspect of a case. Just the same here, you can associate yourself with a consultant or technical person who has that level of competence that you can oversee, that you know and trust and have vetted, and you can rely on that. So, and the third, of course, which is the one nobody wants to use, is you can decline to represent that client. So those are kind of the three things that the various court rulings have put out. You either know it yourself, you find somebody who can help you understand it and is competent and you trust, or you can just not take the work. Obviously, the third one is not something any of us want to do. So, but you'll see as we go through this that the ABA rules kind of go through and touch a lot. And one of the things actually goes beyond that. Louisiana has taken the same thing and applied it to how lawyers use social media. So, Barry, you've done a lot with this. Why don't you tell us a little bit about how that plays into that particular portion?
Absolutely. Thanks, Brian, and welcome everyone as well. Most states, as Brian mentioned, have adopted a version of the ABA Rule 1.1, and everyone has they all have a little bit different flavor in some regards, and as Brian pointed out, Louisiana has addressed the issues of social media in a couple of ways. Obviously, the first one is regarding self-promotion and how an attorney might respond on social media, and they have to be careful to not be rendering legal advice in social media. But the other side of it is that, as the second bullet point says, I will stay informed about the changes in the law, which means that attorneys need to be aware of technological changes as they happen. And in this day and age, there are rapid evolutions of social media applications, not just the regular Facebook accounts, but the ephemeral apps like WhatsApp, and how those are addressed, how those are collected, and how those are reviewed. Slack and Teams are two of the popular chat apps that are used in enterprise situations primarily, and they each have their unique characteristics, and the attorneys need to be aware of how those function, how those need to be collected, how those can be reviewed. So I think we can move on to the next slide here. Just a couple of tidbits of history with respect to eDiscovery. When I was doing a little research here, I was kind of surprised that back in 280 BC, the Great Library of Alexandria started tagging their scrolls to identify author, title, and subject, which sounds awfully familiar today because we need that information when we're doing eDiscovery, and it's particularly important when we're scanning hard copy documents because at least those 3 points are the minimum metadata plus the title, which are critical to know when doing eDiscovery review. And then further on, MIT first referenced the need to have a language to track metadata, and they called it the meta language, and that was back in 1967. So what's relevant is eDiscovery today has the need for awareness of what the various technological aspects are to be able to capture that metadata. And you need to also know what that significance is in your various cases. So turn this back to Brian.
Yeah, Barry. So it's interesting. I mean, one of the things I like about that one slide, it's kind of an interesting tangent, but what it does show, slide get back and forth. All right, there we go. Get right to the right slide. The thing I like about it, by the way, is just the fact that it shows that these issues aren't new. Metadata is not new. Technology is not new. One of the things that we always tell our clients and have had a lot of success when we were testifying in front of courts is that the technology may be new, storage may be new, but the actual basic rules of litigation, the rules of discovery, way back in the day, I remember testifying about, getting to data that was archived in systems that were very difficult. And one of the cases we relied on was a case from the 1970s that talked about how a company was arguing it was too difficult to get their paper documents that they had stored in a warehouse in South America somewhere. And we use that to show that, look, the same basic idea where the court said there, you're the one who decided to put your data there. We're going to expect you to go get it. We're going to believe that when you decided to put your paper documents in a warehouse in Brazil, I think it was, that you're accepting that is going to be a difficult thing for you to get, and that was a risk you took. And we use the same thing to say about, the kind of archive systems. When you chose those archive systems, it was the same thing. And so the point being here is that, when you look at some of these issues, don't let the technology get in your way. You need to be able to understand the technology, but a lot of times the most successful way to handle a lot of it is to figure out how that you can relate to non-technology people, whether it's a jury or a judge or a magistrate or an arbitrator explain these things in ways that don't necessarily focus on the technology that much. And I think, showing the metadata goes back to, 2,000 plus years, shows that none of this stuff is new. And in fact, even technology-assisted review uses, at its core, a lot of it uses math algorithms that go back thousands or hundreds of years as well. So it's just an interesting thing to, don't let that technology scare you. And I think to the extent you can bring in an expert to help you understand, force them to help you understand that technology in the context of not letting the technology stand in your way. So anyway, so the eDiscovery process, we're going to look at each one of these steps and go through this as we go through the next couple of slides. Everything, like I said, from the triggering events, legal holds, custodian questionnaires, data identification, meet and confers, the SI protocols, how you call data, document review, privilege review, and even document production. Every single one of these steps that pretty much goes across the whole EDRM has an ethical kind of component to it when you think about it. And so we'll be talking about each one of these. The first, of course, is triggering events. And Barry, you've talked a lot about this. And just as a heads up to everybody, when you talk about triggering events and legal holds, there's so much complexity to that when you really dig into some of the details on that, on how to do it right and make sure you're doing it right. We've actually done a webinar, I believe, on ACEDS before. We also have it on our website. If you want to dig into an hour-long webinar that talks just about legal holds and triggering events, we made all of our resources on our website for free, so you can go there and find it. It's actually called The Risk and Responsibilities of Legal Hold. So we're going to cover it now and some of the highlights of it. But if it's something you're really interested in, there's a whole other hour-long webinar just on that topic alone. Barry, you want to talk about some triggering events here?
And I should say, by the way, on that topic, the supporting materials pushing 1,000 pages. So it's a well-researched and developed topic. With respect to triggering events, the common law says you need to instruct your clients on the identification of triggering events. And we've got 4 cases listed here below, Cronish, McIntosh, Silva Street, and the Alabama aircraft case. And each one of those 4 cases identifies when the triggering event might happen. In the Cronish case in particular, when the litigation is filed, there's an obligation to preserve data. And in this case, the obligation to preserve evidence arises when the party has noticed that the evidence is relevant to the litigation, and most commonly when the suit has already been filed, and that's a quotation directly from the decision. In the McIntosh case, when there's a summons issued, that pretty much tips both sides off that there's an obligation to preserve. In the Silva Street case, the plaintiff was contemplating hiring litigation experts. And again, if they're thinking about it, then they probably ought to at least be preserving on their side for sure. In the Alabama aircraft case, the duty to preserve relevant evidence must be viewed from the perspective of the party who controlled the evidence and is triggered not only when litigation is pending, but also when it's reasonably foreseeable to that party. And perhaps the poster child for a case which isn't mentioned on the slide, which is the Apple versus Samsung series of litigation that just concluded last year, where both sides were found to have been lacking in doing their duty to preserve. Apple, in the first instance, had notified Samsung that they were thinking about filing litigation for patent infringement. And when they were thinking about it, they had an early meeting with Samsung, and Apple failed to do their preservation. Likewise, Samsung also failed to preserve their information in anticipation of litigation. So the court found that both sides were faulty, and the case moved on, realizing that both sides had that obligation to preserve. And so we need to ask what triggers a legal hold. And if you're in doubt, it's always safe to issue that hold. And there is no specific federal rule on it, but the various rules regarding not depriving your opponent of information and so forth tangentially addresses the issues. So the types of triggering events that exist are product complaints. That's kind of obvious. You have a product failure, and or you've had a product failure, and you're on notice that those things have happened. And if it's beyond just a simple breakdown of the product, but potential injury of some sort, could be the triggering event. Harassment complaints and other HR issues lend themselves to prompt preservation of data, and not only of the typical email events, but also other devices, cell phones, text messaging, and so forth may be today implicated in having a triggering event that causes you to need to preserve your data and issue a hold. And the same, as I mentioned in the Samsung and Apple case, IP infringement. Obviously, accidents and claim letters give rise to the probable need to issue a legal hold, as do regulatory investigations. Receiving a CID tells you you better preserve the data related to that CID.
Yeah, and Barry, that one of the things we always say is that if your client comes to you and asks you, hey, do you think I should issue a legal hold? Then the answer is probably almost always yes. Like you said, when in doubt, issue the legal hold. And we say the same to our clients. We have corporate clients who we sell legal hold software to, and one of the first questions when we're walking them through that whole setup and how to use it and training them, they ask us about what kind of triggering things should we look for, and our answer always is, if anytime you hear of a client complaint, obviously you get a litigation. Somebody comes to you and says, we're going to sue you. We send you a letter or whatever. That's obvious and easy. The more kind of harder things to do is to figure out how to make sure things get bubbled up, right? So it's not just about training the legal department. It's about, and this is something that, as attorneys and consulting your corporate clients and giving them education on this perspective, right? Saying, hey, if you're in a large corporation, especially where you've got a lot of dispersed employees, is soon, you need to train your HR people, you need to train your managers, you need to train your product people so that they understand, hey, if you hear this kind of thing, make sure you bubble it up to legal, or make sure you get with outside counsel or some other kind of centralized person. So it's not just about understanding the process. There is a importance to make sure your client understands it. And courts have even faulted attorneys. We'll talk about this in a little bit in a couple of more slides, but courts have faulted attorneys for not providing that advice to their clients. And they're citing the ethical, ABA model rules and the state versions of it, depending on the state, as a way to say, look, this is your responsibility. It's a legal obligation, and you as counsel, if you didn't make sure your client was educated on this or took the proper steps once they knew the trigger hold, and you didn't make sure that they sent out a legal hold and did it correctly, we're not only going to hold the client, the party themselves, responsible for potential spoliation that comes out of that, but we've even seen courts starting to sanction attorneys. Like I said, we'll cover a couple of those things, a couple of those decisions here in a sec. But once you have that triggering event happen, the next step is to actually then send a legal hold notice. And, I think everybody knows this, but we just kind of put out there what exactly is a legal hold. It's a process by which the organization notifies potential custodians, not just known custodians, but even potential custodians, to preserve information in electronic, paper, or other form in anticipation of litigation. And that could be done via email. It can be done in memos. There's different ways it can get done. And we go into a lot of detail on that in that other detailed webinar. But the important thing is that it happens and that it's overseen by counsel. You can't just, tell your client, oh, issue a legal hold. You need to go in, understand what they're doing, understand how they're doing it, and be part of that process. So, and one of the questions we often get is, why such a focus on legal holds? It seems like a relatively small part. Judge Shinlin's two decisions in the, I'll call it Zuba Lake. I've been in eDiscovery for 25 years, and one of these days I'll make sure I pronounce it right, because I still hear people call it Zuba Lakey. But Zuba Lake case started where she was some of the first big eDiscovery. Anybody who's been in the industry for a long time knows these cases like the back of their hand because they were kind of really set the bar early on in eDiscovery, talking about identifying data, preserving data, taking steps to make sure you've suspended, destruction process and all sorts of other things. And that goes through the entire process. And as you'll see, but Zublake really kind of focused in more than anybody else did on how litigation hold affects sorry, lost my train of thought there. How litigation holds affect eDiscovery and electronic data. Sorry. Several years later, what really touched it off was her pension committee decision, where she came out and said, it's black letter law, it's sanctionable conduct. If you don't issue a legal hold, you're going to have sanctions, you're going to have problems. Now, the Second Circuit came back and rejected that, basically saying, well, what about the one-person LLC or certain circumstances? You couldn't make it just a clear black letter. But it sent ripples out, and people started, again, paying very much attention to legal holds, to the extent today that, like I said, courts have started holding attorneys personally responsible for it as well. So let me just slip to the next slide here. Not only when it comes to this kind of stuff are we talking about the model rule, but also the Federal Rule of Civil Procedures has some of this kind of ethical responsibility tied into it as well. Barry, you want to talk about the Federal Rules 36E?
Sure. As we know, Rule 36E was amended rather significantly in 2017, late 2016. And before it said, well, if by operation of a system you didn't preserve data, that was probably okay. But the rule is now more focused on the fact that if you can't locate that information within a custodian for whatever reason, but you can find it elsewhere, that's not a free pass, but it is a pass to allow you to produce data that may otherwise not be accessible. And the key point is whether counsel was unable to, had the intent to deprive another party of that information. And we have a case here, the Snyder versus Danfoss case, and it stepped through the notion of intent to deprive and whether or not the party in this case did indeed intend to deprive the other party of the data. And in this case, Danfoss had a policy to delete emails 90 days after an employee left employment and did so. And 6 months after a particular employee departed, a litigation was filed. And, of course, they didn't have the email for the specific custodian because it had been deleted. However, the defendant offered to and did produce emails relevant to that particular departed employee that were mined from other custodians, other employees within the organization. And the plaintiff said, well, you didn't give us the information from that particular custodian, so we're filing for sanctions. And the court determined that there wasn't any intent to deprive, and hence there were no sanctions. Though the judge in that case did say, well, the examples that you used in the in-camera session discussing the fact that you didn't intend to deprive can't be used in summary judgment. So there was a slight limitation there. But regardless, the notion is, and we see this in cases that we deal with our clients today, where a custodian is gone, there's been a loss of data, there's been, for whatever reason, technological issues or what have you, but the information was able to be gleaned from other places in the organization, whether it was a file share or other custodians. That goes to address the issue of not intending to deprive the other party. And conversely, if somebody did, then sanctions will follow. And we have several cases here regarding the risks of not issuing the legal hold and then targeting the counsel for failure to do what they should have done. In the first case, the judge ordered the law firm to face malpractice claims for the failure to advise the client to issue a litigation hold. Each of these first three cases has a common thing, that the counsel has a duty to advise their clients. And not only that, to advise the clients, but to ensure that they properly supervise and monitor the holds. Because it's not just one thing to issue the hold. Once a hold is issued, there are ongoing responsibilities and obligations of those custodians to maintain records and documents as they existed, but also as they're being created along the way regarding a particular claim or matter. And so each of these three cases, the industrial quick search one, the Pomeroni case, and the Suarez case, are all very, very important. In the Pomeroni case, the court specifically faulted the outside counsel for not properly overseeing the discovery effort and the legal hold. And the reason for that was outside counsel had relied upon, and the corporation had relied upon, a non-attorney to manage this. And that non-attorney didn't have the forethought and the gravitas to follow up and supervise the hold. In the Suarez case, this was a situation where the U.S. attorney was faulted for not issuing a litigation hold to the FBI until 7 months after the case was underway. And then lastly,
I always found that interesting. That one interesting, Barry, just because it shows how serious courts are. If the U.S. Attorney's Office has to tell the FBI to retain data that they're subject to a litigation hold, you'd almost assume that's a given. But I just think that's really interesting to show how seriously courts have taken it. And the Hayesville case is really interesting because it's kind of the opposite, but I'll let you talk about that one.
Yeah, in Harleysville, this was a situation where the plaintiff had inadvertently placed privileged documents on an unsecured server, and opposing counsel for the defendant said, well, I see that. And not only did he see it, but he shared that information with other co-counsels in the matter. And so that goes to the ethical responsibility that if you see information that should not have been released out into the wild, you have an obligation to let your opposing counsel know that happened, and then you're also precluded from using that information in support of your side of the matter. And as a result, obviously, the counsel was sanctioned, as there was that ethical duty to play fair, inform counsel of the issue, and not use what had been seen.
And so the next kind of step we have here, the next step in the process, of course, once you've issued those legal holds, is then identifying and collecting the actual information that is subject to those legal holds. And so we talk about legal data preservation, collection, kind of bridges the gap between both of those steps. And so, of course, obviously, the thing we talked about is that first step, notifying people of the need to hold. That's the whole legal data side. But then also going and making sure that that data is actually being maintained. Part of that is, like Barry mentioned before, there's all these issues of automatic deletions and older data being purged out of systems. It's important that you look, when you first get involved in a case, to talk to the client, talk to IT, bring in experts to help you do this. Again, if you're not comfortable doing it yourself, to find out what kind of policies they have like that. Do they have an email deletion policy that they need to suspend? If a lot of legal hold systems that corporations have, like Office 365, for example, which is very prevalent in corporate America today, you can put people on legal hold inside that system. And actually a lot of legal hold software will integrate with Office 365 as well, so that when you issue a legal hold, it'll automatically put people on legal hold within Office 365. And what that does inside of Office 365 is make sure that any kind of deletion policies you have get suspended for those individuals, as well as making sure that anything they delete, intentionally or unintentionally, doesn't actually go anywhere. It goes into what used to be called a legal hold dumpster, essentially, the individual might not see it, but you can still, as the corporate client, get in and the corporate owner of that profile, get in and search for data and still discover it because it's on legal hold. So, it's important that you talk to the corporation, but specifically IT. Don't just talk to the CFO, for example, in that to use the example of that other case. Get to the people who really know and run these systems and find out what kind of automated deletions do they have, what kind of data purging do they have, and then figure out whether or not that needs to get stopped. Obviously, if you're talking about a products liability case and they've got some deletion policy that has nothing to do with it in some other system, then it doesn't necessarily mean they got to stop everything. But you do need to figure out what's there and make sure you suspend that. And part of that goes with this kind of third step here is system and data identification, right? The only way you can be sure that you're preserving everything is that you spend time as early as you can to figure out what all those systems are. And we're not talking about just email. Email is easy. There's a lot more areas to consider. There's a case that we cite in the bigger legal hold presentation, the TellerMate case, I think it's called, where Counsel was faulted because they claimed, oh, hey, all this information, it was a commissions and sales performance wrongful termination case, I think, of a salesperson. And that salesperson said, but look, hey, all my history is in Salesforce. And the attorney came back and said, well, that's Salesforce. We can't control that. And the opposing counsel came back and said, well, read your contract. Your contract with Salesforce says that you do control that information. It is your information. You have the corporate client at least had complete control over it. And because the attorney didn't take any steps and the corporate client didn't take any steps, the data that was in Salesforce got written over because of the way they used Salesforce, and they got sanctioned for doing that. So it's important that you dive in. Yes.
Let me add a point on that, and that's the terms of service for a lot of these cloud resources, social media sites, and so forth. The terms of service govern where the data is, who owns the data, and so forth. And it's incumbent upon Counsel, when they're involved with those types of platforms, to know what the terms of service are and what the expectations are. And the TellerMate case is what I would consider the poster child for delving into the terms of service to know what the obligations might be.
Absolutely. And then, of course, the last step is, once you've identified all that stuff and preserved it, is actually gathering it and collecting it for then processing and analysis and review. One of the best ways, by the way, is to involve custodians in this. And everybody's familiar with kind of the custodian questionnaires, the classics. We'll talk about that on the next slide. But I can't stress this enough, is the forget about where the dead bodies are buried. The custodians, the individual employees, they know where their data is. And it's more important than ever, because data doesn't just live in computers and servers and email systems and things like that. It could live in everything from Slack to Teams to Salesforce to all sorts of social media accounts, whatever, depending on the nature of your case. One of the biggest, fastest growing areas of our business today is social media collections, because people are realizing that there's an awful lot of information, not just for personal injury or med mal or whatever, but there's an awful lot of information on social media that people just put out there in the world that we've seen, a couple of $1,000s worth of investigation on a social media and a multi-million-dollar personal injury case. Or med mal case, or employment labor claim. So you really, really, really need to talk to the custodians and find out, what do they use every day? What platforms? How do they talk to their coworkers? How do they talk to their customers? Where do they store their data? Do they keep to-do lists of their own on some other application? The custodian questionnaires have never been more important. Involving those custodians have never been more important. Plus, when you do it, you also ask like a stop question here. Stop questions is kind of a technical term, and the idea there is you start out by asking the custodian what their level of involvement is, and if you find out from that custodian questionnaire, talking to the custodian, that they didn't really have any involvement, you can move them at least to kind of a secondary status, if not eliminate them as a custodian altogether and release them from legal hold. So you can use those to find out whether they're even the right people to talk to. interestingly enough, people are like, well, yeah, but custodian, who's going to reply to this? Our experience has been that custodians will do the right thing, and they'll take this stuff seriously. They get this kind of a legal notice. They know there's a litigation. We're all kind of immune to it from being in the legal industry, but your average employee who's not involved in legal on a regular basis is going to take this stuff very seriously. And again, as counsel, if you see somebody who's not, then you can reach out to them and handle that on an individual basis. But it's the custodians are one of the most important things. And when it comes to ethics, again, goes to that level of basic competency. The last thing you want to do is be in front of a judge and explain why you didn't involve custodians, why you didn't go out and ask. They're going to expect that you understand that you have to do that. And there's a little quote here on the bottom right of this slide from a court where the judge said there needs to be a lawyer who goes out and makes sure that the collection is done properly. In other words, you can't just leave it. It's your responsibility as an attorney, and again, gets into ethics about that. So the custodian questionnaires, one of the most important things about custodian questionnaires is, especially in this time of remote workers and people being all over the place, a good survey engine will allow you to send out a custodian questionnaire to find out where all this data exists, find out what kind of things. That'll inform how you work with your client to make sure things are preserved and make sure IT processes are suspended. But also, one of the things you could use custodian questionnaires for, just as a side note, is especially now you can ask them facts. Were you in this board meeting? Were you involved in the development of this product? Were you involved in the marketing pitch on this product? Whatever, cases, information about your actual case. Don't just think of a custodian questionnaire as saying, if you're sending out custodian questionnaires and all they say are, what email do you use? Where do you store your personal data? That kind of stuff. You're missing an opportunity to really leverage these things to the fullest extent. They're privileged. Custodian questionnaires are absolutely privileged, absent some massively extraordinarily strange circumstances. They're communications between counsel and the client or the client's employees. And so you don't have to worry about asking them questions that might be factual and you might be concerned about privilege. So, plus, if you use custodian questionnaires right, you can really focus in and figure out who your key custodians are, so you can really get to the heart of the matter that much faster as well. So, custodian questionnaires not only help you meet your ethical obligations, but they can, especially in this remote working world we're all in today, can be an excellent tool to help still communicate and gather the facts you need to, regardless of where your custodians are. And some of the last things, like I mentioned, don't forget to ask about social media, about texting. Do they use cloud storage? What kind of devices do they use? What kind of applications do they use? Are they using, are they using something like Signal or one of these other communication apps on their own to discuss work? Whether it's sanctioned or not by the company doesn't matter. If you have an employee who's using Signal, for example, to communicate with their fellow workers, Signal is one of these chat apps that you can actually set to delete messages pretty quickly, or not at all. It's up to you. If they're using that, even if it's not company sanctioned, it still falls under the duty of identifying it and preserving that information. Just because the company had said, hey, you shouldn't use this, if the employees did and there's information that might be relevant to a case, guess what? It's still relevant. So when you issue those custodian questionnaires or you talk to employees and you do your interviews and you're looking at these systems, you got to think about all of these very broad, the places where you can store data today are just unlimited. We even have cases where we've talked about collecting from somebody's Xbox because they were using chats at Xbox to talk back and forth, thinking that nobody would find it. And so this is another place to really bring in an expert to make sure that you're covering all your bases, because the last thing you want to do is have to go to a court and explain why not. So our next topic is the Meet and Confers and how the ethics kind of come into that. And Barry, you talked a lot about Meet and Confers, so why don't you talk about this topic?
Thanks, Ryan. There is an obligation under Rule 26F3 that directs the parties to discuss the form or forms in which electronically stored information might be produced. And we at BIA get involved with helping our clients draft meaningful ESI protocols that govern maybe the number of custodians, the locations where a custodian questionnaire is identified that data might exist, so that those points need to be addressed in the ESI order so that nothing is left unturned and undiscovered that should be. And so when the parties are meeting early in the case, it's incumbent upon counsel to discuss the methods and means of production, when it's going to happen, how long it's going to take, the form of production, the information that's going to be disclosed in the production, the various, as we mentioned in the history slide, the various meta points, the metadata points in the data that are meaningful. It's often important to know what the organization is that a custodian maintains their email. How many email folders do they have? Where do those emails come from their organized Outlook folder? Excuse me. And also what the original file paths were for that data. Sometimes that is very meaningful because it may lead to ask the question, well, did you get everything from that location when you're looking at the data that's been produced? And so there is this obligation, and it flows through from the ABA rules as well, to make these meet and confer conferences very meanful. And one of the things that should be also discussed, and it's an ethical oversight, and as Judge Peck has discussed over the years, he considers it malpractice to not have a clawback order, so that if you inadvertently produce privileged information, you have the right to request it back, and the other side has the obligation to return it or destroy it, depending on how your request is put forth. And we'll come back to the ESI protocol in a few minutes, but now I want to move on to discussing some of the more current technologies that we deal with when we're talking about reviewing the documents and getting them ready for production, and that's the Advanced Analytics and Technology Assisted Review. And it used to be that you needed to have a data collection that was significantly large enough to be able to afford to use these advanced tools. Today, it's pretty much a commodity. It's not very expensive, and it's typically used from BIA's perspective, in every matter that we touch. And we recommend it to our clients because of the advantages associated with it. And advanced analytics is most often used when the collection of data is email or text heavy. It's used significantly to facilitate privilege review so that you can identify similar content in other documents that you may have missed by using these tools. It's also, and that allows your privilege log to be consistent and the claims to be appropriately stated in the log so that contesting of the log is minimized. Further, with opposing party and third party productions, it helps facilitate your review because you can then identify documents that you've already seen because you had them, but you can also identify new materials, and you can also identify concepts that should have been presented by the opposing party that were not. And you may have a spoliation claim or a claim for them to go back and identify and produce additional documents. And further, using these advanced analytical tools allows you to increase not only your accuracy, but your efficiency in getting through the documents. And so some of the tools on the right-hand side that we use are email threading, which is commonplace today, so that when you're reviewing, you're only reviewing the most inclusive set of emails in the chain. And obviously with email threading, if there's a branch off where I send a document to Brian that wasn't in the regular email chain, that particular document would also be seen. It allows for near and exact text deduplication so that you can group similar documents together, which is also clustering, so that you can review much more efficiently and have consistent coding across the groups of documents that are very near in content to each other. And we also use advanced technology-assisted review methodology, and I'll talk about that in a second. And it's also important now that we are dealing with a lot of global companies that the concept of foreign language is popping into many of our reviews today. And these tools can assist in identifying foreign language. And that's important because you may need to retain foreign language speaking reviewers to get through the documents. Brian?
Yeah, and so there's not only can all of this stuff help make sure things like that, especially things like privilege reviews, right? Making sure that anything you mark as privilege, you can use this technology to make sure you don't miss anything else, or anything that gets redacted, you don't miss anything else. I remember as a young lawyer back in the 90s, when before a lot of this stuff even was a thought in anybody's head, whenever we would get a production that had something redacted, the first thing we do is look for other documents that had similar content, and a lot of times those similar documents wouldn't be redacted. And you could look at that as an ethical failure, an obligation failure. You're not protecting your client, and in those circumstances, it had more to do with, well, somebody was reviewing this one and somebody else was reviewing that one, and they had two different, two humans had different opinions, and they may both had value or certain validity to it. But those kind of things, and courts are starting to recognize this. They're starting to say, look, you need to use this technology that's out there to make sure that those mistakes don't happen. It's before it might have been excusable, but now there's this technology there to help make sure that it doesn't happen. And courts are starting, I haven't seen a court that has sanctioned an attorney specifically for not using this stuff, but I have seen courts that have said, have gone about as close to that line as they can get. Not only is it just to ensure accuracy and completeness and making sure you're taking advantage of this artificial intelligence to not only protect your client, but to make sure that everything that should be disclosed is being disclosed. But just as importantly, to save your client money. Courts will look at it and say, isn't there some obligation here to use the best technology you can, not only to make sure you have consistency and you have all your obligations, but also to make sure your clients aren't wasting money. And especially when you talk about technology-assisted review and some of the advanced analytics and most inclusive email threading and stuff like that, can save significant amounts of money. And courts have started to kind of put this thought out there that lawyers should at least be thinking about that when they're deciding on what technology to use in some of their cases. And so it's also how it comes around to the ethics side of things.
Absolutely, and it's important to vet your resources and be assured that they know what they're doing. Many of the advanced tools, and I'm not going to mention any by name here, but they all have the more popular ones all have certification programs, and you should be confident that if you're retaining a vendor, that vendor has certification and quality assurance based upon the tools that they're using.
Yeah, that's a very good point. Is one of the things we always talk about in the technology-assisted review is the idea of garbage in, garbage out, right? A lot of your results and the quality of what you're getting depends on the knowledge of the people you're using, and so vetting that is very important. And again, you don't necessarily need to know the technology to be able to talk to somebody and realize whether they know what they're talking about or not. So kind of goes into this whole document review considerations. We've covered a lot of this stuff, but go ahead, Barry.
Yeah. I'll run through this fairly quickly. It's important to have a well-written review protocol so that the team that's doing the review and the team that's managing that review team knows what the expectations are, what's responsive, what's not responsive, what the key issues are, and so forth. Establish your review priorities. Know which custodians need to be reviewed first, which issues need to be focused in on. Have knowledge of the review platform, as we were just saying. If you have vendors that have certified managers of review team platforms, you'll get a better result because they can fine-tune and make the review platform hum the way it needs to hum for that particular matter. And again, know what analytical tools and uses are there on the given platforms. Not every platform is equal. And make sure you have clarity regarding what the confidentiality and privilege issues are in any given matter. It goes without saying that there are nuances with privilege depending on what your case is, and there are nuances with respect to confidentiality. In IP cases, there are many times where there are attorney's eyes only designations for certain documents. And then make sure that there's a way to have questions bubble up from the review team up to counsel and to the client. And there should be a defined process that is usable so that nothing gets left unturned if there's a question. And one example on technology assisted review, I'll give you this quick example on a matter that we recently had. There were post-keyword searches, 500,000 documents. We had a timeline of 30 days. And using technology-assisted review, we only were required to review 65,000 of those documents, and you can see the precision or recall results are 92% recall, 85% precision, and we ended up producing 220,000 documents, and the cost advantages are significant. It was a 50% savings in costs in terms of time and efficiency.
And by the way, that also gets into some of your discussions that you may have with a judge about burden, right? You're seeing more and more judges saying, well, if you use the right technology, you wouldn't have the burden that you're arguing about. And so, that's just that example we gave you, just to give you a real world example of how that translates into real money. And courts are going to say, if you go to them and say, well, we've got to review 220,000 documents and it's going to cost $375,000, the court's going to come back and say, well, would it be a lot cheaper and a lot less burdensome if you use this and if you use technology with that? And so that would just kind of give you a real world example of how that argument then plays out and what you should be prepared to discuss. If you're trying to make a burden argument around review, you're going to have to at least address the technology assisted review side of it as part of that burden argument. And you're either going to need to know enough about it yourself to have that conversation or be able to bring in somebody who does.
And moving on to some other considerations that you need to be aware of today and be ethically bound to examine them, particularly GDPR, which is cross-border discovery. It impacts cross-border discovery in the U.S. when we're dealing with EU-based organizations. And fortunately, unfortunately, many other countries have adopted similar laws and regulations similar to the GDPR. Israel, some of the Far Eastern countries as well, have almost identical requirements. There's a recent Supreme Court case, Intel versus Advanced Micro, that set out a four-factor test for whether cross-border discovery is appropriate. And before I give those four steps, GDPR and those types of laws, if you're not certain, and most of us are not, it's what the impacts are, what the nuances of those regulations and laws contain, it's incumbent upon you to retain local privacy counsel who can guide you on the rules of the game when you're in the EU and or in some other country that has a similar set of requirements. With cross-border eDiscovery, back to the Intel versus Advanced Micro, the tests are whether or not that's appropriate. Is the producing party a participant in the proceeding? What's the nature of the foreign tribunal in the proceeding? Is the request there to circumvent foreign or U.S. law? And is the request unduly burdensome? Many of the issues in eDiscovery go back to burden, and it's something to be mindful of. And then we have other issues with respect to data that may come into play. Your personal cell phones that bring your own device to work considerations, the Internet of Things devices, data in the cloud, chat, instant messaging, text messaging, and as we mentioned a couple times earlier, the ephemeral apps like WhatsApp and Signal and things of that sort. How do those all play into your discovery needs? So if you're in doubt, it's important to seek the appropriate technical resources so that you can cover all those bases. And you'll identify the bring your own device issues, the Internet of Things, the cloud, chat message, and so forth, when you're interviewing your custodian through a well-thought-out custodian questionnaire and in-person interviews.
And we have jump 2 slides there. 2 last slides we're going to cover really quick because they're pretty self-explanatory, and we want to leave a couple of minutes here for questions at the end. But the last thing, after you've done all this and you've done all your review, is production, right? And people will say, well, how does ethics get into production? And really it comes down to, not only what you're doing as an attorney to produce documents. And, gone are the days largely where people are having really deep arguments about what metadata to produce and things like that. And instead, there's kind of an expectation of what's going to get produced. And if you don't do that, if you don't produce kind of standard metadata with your production, unless there's an agreement of the parties, then courts are going to come back and say, look, this isn't, you have an expectation to produce documents in their completeness, in their entirety, including their metadata. And we're not going to let you screw around with that. And we've even seen some companies come close to getting, or some counsel come close to getting sanctioned because they tried to game that system because they thought maybe their adversary wasn't smart enough to figure it out. We had one case, this is a couple of years ago, where somebody was like, oh, we want to just produce in non-text embedded, image-only PDFs. And we went back to the corporate client and said, this is going to be a problem. And the attorney in that case was basically took the position that, look, they didn't ask for it. The attorney, the plaintiffs in that case had no idea what they were doing when it came to eDiscovery. They didn't ask for this stuff, so we're not going to give it to them. We're just going to give them not even text, not searchable text of any kind. They just gave them clear images with nothing else. And we went to the corporate client and said, look, because we had worked with them on a lot of cases. We were like, look, this is not what you've done in every other one of your cases. And you're going to end up spending a lot more money, and you're going to end up going through litigation, and you're going to, because at some point, that was an MDL. So at some point, there's going to be another law firm that comes along who does understand it. And guess what? It's exactly what happened. And everything had to be redone and done with a regular type of production. So there are ethical considerations that come into that as far as just being a fair and reasonable person when it comes to that. But one of the most important things you can do when it comes to production to make sure you don't have any issues like that is to do a full-on protocol that covers everything from, custodian identifications and to clawbacks to, if you're going to use technology or analytics in the review, what you're going to do and what the parties agree to that, to defining exactly what's going to be in your production, how the form and format, what's going to be TIFFed or PDF'd, and what's going to be native, what metadata fields are going to be included. If you have all that stuff written down and everybody agrees to it, we've seen cases where parties have agreed to a protocol, and then one party comes back and says, well, wait a minute, we want all the data natively. And the court said, sorry, you have assigned a stipulated protocol that didn't say that. It specified TIFF productions. We're going to hold you to it. So the best way to protect yourself against any of that kind of stuff, any claims of whether you're gaming it or you're not doing something, or worse, you didn't know what to ask the other side for, and that prejudiced your own client, the best way to do that is to have one of these protocols and to bring in an expert as well. If you don't know all the details yourself, again, bring in that expert who can give you the advice on how to make sure you're covering all the bases. And the last thing is, of course, the ethicals, the ethics in certifying eDiscovery. This is something that it doesn't get a whole lot of attention, but Rule 26 says that you have an ethical obligation to make sure that you're fulfilling the duty of disclosure in a case. You have this obligation under the federal rules to sign off and talk and certify the completeness of discovery. And if you haven't done all this along the way, you can't do that. And if you can't do that, or if you try to do it without knowing what you didn't do, then again, gets into ethics. Barry, do you have any last points? Because I want to leave at least a couple of minutes for us to answer questions. We'll go over the time if we're able to answer some questions.
No, I think we're good here, and we should jump into the questions.
All right. So first question I see, Mike, I've got them. I don't know if you want to read them out. I can read them out. It's up to you.
Totally your call, Ryan.
I'll just go through, and the little system gives it to us here. So the first question was, is there any ethical obligation to disclose to an opposing party or the court that you have used TAR to review and produce ESI? Barry, that's probably more for you. I think the easy answer is no. But again, this is something that a lot of people will put into their protocols now. But Barry, you want
to? I agree with you, Brian. The easy answer is no, unless the parties have agreed to it otherwise. To call out what was done, how it was done, what tools were used, what your precision or recall might have been, and if the parties didn't discuss ahead of time, then it's a sort of fair game to produce as appropriately. And the last slide that we just discussed is the ethical obligation to sign off on the production that it's as complete as it can be, and that you've done it appropriately and not withheld information that shouldn't have been withheld. And in the old days, in document review, we say there is no bad document exception. And so, the smoking guns do need to be produced. And so going back to the specific question, if the parties have discussed it in the ESI protocol, then that is the governing rule for that particular matter. But if not, as long as you're getting the documents reviewed and produced in an appropriate manner and the production is complete from a topical perspective, responding to the various requests for production of data and so forth, then that's how it can be.
Yeah, when technology assisted review first came out, there was an awful lot of questions about how do you do this and how do you disclose it. And originally there was a lot of back and forth. And I think more and more courts have just gone kind of back to the old school, forget about the technology, look at what actually happened, and have said, look, if you can prove as the receiving party that you think documents were missed or things weren't, then you can dive into how things were selected and how they were produced, just like you could with any other section of it. So, you might have to answer questions on how you use technology-assisted review if there's a reasonable, clear showing that data was missed by the other side. Then they'll dive into it. But without that, courts are more and more reluctant to say, look, whether you're using individual attorneys, you're using outsourced, you're using technology, whatever process you're doing, your ethical obligation as the producing party is the same. Period, end of story. And so if there's a question on that, then they'll get in and start letting the opposing party ask questions about it. But if the other side can't prove that there was some question, then it isn't going to be an issue that they'll really dive into as much as they did at the beginning. Another question here: what obligation does a lawyer have to advise their client regarding social media posts, for example, after an accident? Can a lawyer tell a client to make their social media posts private, thereby shielding the posts from public view? It's a very interesting question. We've been doing a lot of social media stuff, and I think there's some articles on this if you want to dive in on our resources page. But the short answer is, that might be surprised, yes, they can tell their client to make their entire thing private. What they cannot do is advise them to delete information or to go back and change information that might be relevant. And in fact, lawyers have gotten sanctioned and their parties have lost the entire suit because a lawyer has said, go clean up your Facebook page. It's kind of like, is it Arthur Anderson telling their accountants to clean up their Enron files, right? You cannot do that. There's nothing wrong with making it private because it's still there, it's still preserved, and the producer, the requesting party can still say, produce it. And it's there. So it's not a matter of kind of public-private view. So it may be surprising that that's the case, but the answer is, as long as it doesn't destroy any of the data, then whether it's public or private doesn't matter. You still put it out in the world. And by the way, just because somebody marks something as private on social media doesn't mean it's not discoverable because it's hidden somehow. Courts, rejected that one.
And there's case law on point.
Yeah, there's some case law on point. I think we've got some articles on that as well. There's a lot of talk about, here's the next question. There's a lot of talk about supervising junior attorneys today because the bar exam is being postponed. Very interesting. What are lawyers' supervisor responsibilities when it comes to overseeing new lawyer work or when engaging a service provider who may not be a lawyer? Actually, in our...
I could address that.
Yeah, this is a topic we addressed specifically in that legal hold thing about, representing it, responsibilities of junior and senior lawyers under the ethical rules. So, Barry, go ahead. Sorry, didn't mean to cut you off.
Oh, yeah, there's an ABA rule specifically on point that the supervising attorney or the senior attorney has the ethical obligation to look over the shoulder of their junior team members. And
so yeah, and that goes along the entire process. All right, one more I think we've got here. Our law firm is in receipt of numerous productions from opposing counsel. They're always in PDF format. It causes us tons of issues and costs to get them into relativity, and we're always missing metadata. Is this ethical on their part? What can we do? We feel like they're doing this on purpose. Like I said before, now again, this will come down to the court or the arbitrator or the mediator or whatever party you're in front of. More and more judges, if you went to the judge and said, or even to the judge's clerk or magistrate and said, look, this is what's happening. It's completely unusable. The federal rules are pretty clear. The data has to be produced in a usable format. You can go into the whole thing of it should be produced in the form in which it was kept. And so, yeah, if you have somebody who's doing this and they're doing it on purpose, now you may have somebody who's doing this who's just doing it because they're not competent to do it the right way, which is a different story. But if they're doing it on purpose, like the sample I talked about earlier, then yeah, that's unethical, clearly, because they're specifically doing it to hamper your access to that information. And courts not only are going to slap people on the wrist, but they'll probably sanction the parties for doing it if you can prove it was intentional. And it's absolutely unethical. I mean, look, at the end of the day, whether it's the discovery or any other part of litigation, courts don't like games, and that's clearly would fall into that category. I think we've got one more here. Looking ahead on with the unprecedented surge of remote workers, small, medium, and mid-sized and global organizations, what foreseen legal road barriers with eDiscovery process and obtaining legal hold and preservation to U.S. data on international virtual cloud servers? Does GDPR address the steps? This is a topic that we could spend an hour talking about, I think. The biggest thing that corporations are going to face with the remote workers is, to the extent corporations weren't prepared for this and kind of left employees to their own devices to figure out how to access their corporate data. And now you may have all sorts of corporate data on personal computers and tablets and whatever that might no longer exist on the corporate networks. Then it's going to make it much more complicated and something you're going to have to talk about. It's actually, that's a good point. When you're talking to IT, you can talk to them about, okay, what did you do in COVID? Like, how did your employees access and save their information? In our corporation, we're very much in the cloud already with Azure and Office 365 and Microsoft Teams and all of that. So when we moved over, and all of our employees have encrypted laptops. So when we moved over to remote, it was all the same corporate-owned equipment, encrypted stuff, online systems. So we don't have this issue because we were already there. But we do have clients who weren't there at all and didn't have computers so their employees could go home, and now they're using all their home computers. So it's a really big question and something you need to be concerned about. And Barry, do you want to say anything about GDPR really quick in that?
Well, with COVID-19, the courts and judicial journal proceedings in the EU haven't figured out how to deal with the various privacy issues yet that are related to tracking and so forth of infections or contact points for individuals who have become infected with COVID-19. And so that information, once it's being accumulated, has not been addressed with the various tribunals in the EU yet as to how that information is protected under the GDPR rules, which are rather stringent. And I suspect that there will be some carve-outs going forward.
And so that was the final question. We'll put some probably a little bit more detailed answers to some of these questions on our blog post as well. And just to give a little quick shout out, in about 2 weeks, tentatively scheduled for May 6th, everybody on this will get a notice and an invite to our next ACEDS sponsored presentation, where we're going to talk specifically about some of the impacts of COVID-19 and the lockdowns and everything else, on specifically not only how is that going to change some of the process in eDiscovery and litigations and discovery in general, not just eDiscovery, but also, very importantly, some clear, at least 7 steps, 7 ways in which you can implement some of this technology and processes to help significantly reduce the cost of eDiscovery. Because like you saw the TAR example before, and that's just the tip of the iceberg. Not only is everybody having cost pressures from the pandemic and having to reduce budgets and reduce, the last thing we want to do is see people spend money on eDiscovery and have to let employees go because they don't have the money on it for it. So we're going to be going through every step of the EDRM process and giving you hints and help. How do you control that budget? How do you bring it down? Because even after the pandemic is gone and we get back to work, the economic and potential recession impacts are going to last a while. So it's a hot topic. We're helping our clients identify it a lot. We're putting it together, and hopefully we'll sell you back for that. And with that, I think, Mike, we're done.
Great. Thank you, Brian. All right, everyone. Thank you so much for joining us on the ACEDS webinar channel today. Thank you to Brian and to Barry for a fantastic presentation, and, of course, our partner, BIA, for a great presentation. You can visit BIA at biaprotect.com. And please visit aceds.org for a complete list of our upcoming webinars. Have a great day, everyone.
Thank you, everyone. Have a great day. Stay safe and healthy.
Bye all.